In this section, we'll be covering written buyer agreements. Written buyer agreements cover both exclusive buyer agency agreements and showing agreements. This is an NAR settlement requirement as of August 17th before realtors start touring homes or working with buyers. What's the difference between an exclusive buyer agency agreement and a buyer showing agreement? An exclusive buyer's agency agreement establishes a fiduciary relationship between a buyer and their buyer's agent. It outlines the agent's responsibilities in representing their buyer during the home buying process. Typically, this agreement is exclusive, meaning a buyer won't hire another agent while searching for a home, and covers the NAR settlement term, which requires a buyer to sign before touring homes. On the other hand, a buyer showing agreement is more limited as a transaction broker. This form also covers the NAR settlement term, which requires a buyer to sign before touring homes. Essentially, both agreements serve to clarify expectations, fees, and services which protect both parties' interests during the home buying journey. NAR policy will not dictate the type of relationship the professional has with the potential buyer. 2. NAR policy will not dictate the term of the agreement, whether it's 1 day, 1 month, 1 house, or 1 zip code. NAR policy will not dictate the services to be provided. And finally, NAR policy will not dictate the type or amount of compensation that is charged, whether it's $0, X flat fee, X percent. Before we get into the Valley MLS buyer showing agreement, I want to point out a few things, some questions that come up for practitioners out in the field, and when they have to use a buyer agreement. The first question is, what if I'm hosting an open house and an unrepresented buyer comes to the home? Do I need them to have them sign a written buyer agreement? And the answer to that is no. Since you are simply working for the seller in that capacity, and if you are simply providing basic information like a handout and showing them where the kitchen and the bathroom is, then you would not need them to sign. But if that potential buyer starts asking for particular services, or you provide representation in a more formal manner, then you would need to have an agreement signed at that point. The other question I get quite a bit is, who needs to sign a written buyer agreement? So let's say you have a large group of people that enter a property on a weekend. You need to determine who the client is, who is going to be the buyer. So then you would have that particular person sign the agreement. The other question I have quite a bit is, can buyer showing agreements be amended? And based on the NAR settlement terms, the answer to that is no, but NAR Legal has mentioned that all agreements are amendable, but they highly discourage that you do that. So when you are defining your specific services and fees in a written agreement, you will be putting down X percent, Y dollars, and you should stick to that. If somewhere during the course of showing properties that you want to increase that amount from X percent to Y percent, NAR Legal highly recommends that you document everything very clearly with the buyer. It's in writing, and it's approved by the buyer. And so that you really want to, again, avoid having to have that discussion where you're asking for more than your original contract with that buyer. So those are some of the things you want to talk about. But I will reference you to please visit facts.realtor, their FAQ section. That's facts.realtor, that talks about written buyer agreements in a lot more detail. But let's get into the discussion here about this particular form, which is the Valley MLS Buyer Showing Agreement. So starting August 17th of 2024, An MLS participant working with a buyer will be required to enter into a written agreement with the buyer prior to touring a home, including in-person and live virtual tours. Starting from the top, working our way down, this is the Valley MLS Buyer Showing Agreement. At the top, you'd want to date it. In paragraph number 1, you'd want to define who the customer is as the buyer. Paragraph 2 talks about the customer appoints licensed real estate agent. You would put your name with your brokerage in the second space to assist customer with transaction brokerage services in showing acceptable real property for purchase located. And again, you can put city, a state, a zip code, subdivision, whatever you deem is necessary for this particular transaction and client. Paragraph 3 talks about notices and correspondence with this agreement, including amendments thereto, shall be in writing and shall be delivered via email or text, and this is where you would put the buyer's contact information. Paragraph 4 talks about a period of agreement, and as the prior slide said, NAR will not dictate the length or term of this agreement. So again, it can be 1 day, 1 week, 1 month, whatever you feel is necessary for this particular client and transaction. Number 5 goes into transaction brokerage services. So please take a moment to read that and review that with the client so they have an understanding of that terminology. Moving on to paragraph 6, talks about compensation. There are some required disclosures that are to be made through the NAR settlement, and that is already taken care of for you in the first 4 bullet points. That real estate agent must conspicuously disclose the amount or rate of any compensation received from any source. The second bullet point says the amount of compensation must be objectively ascertainable and may not be open-ended. For example, what you would not want to do is buyer broker compensation shall be whatever amount the seller is offering to the buyer. It should be X dollars or Y%. The third bullet point says the real estate agent may not receive compensation from any source that exceeds the amount or rate agreed to with the buyer. And again, as I mentioned previously, those fees could be amendable, but highly discouraged. But if you do so, document, and have those changes with written authorization from the buyer. Fourth bullet point, broker commissions are not set by law and are fully negotiable. Let's talk about the retainer fee. A non-refundable retainer fee is to be paid by the buyer in the amount of X dollars and is due from the buyer at the time of signing. The buyer is aware that the retainer fee, and this is where you could check the box, is allowed or is not allowed to be paid to the buyer's broker in addition to the brokerage fee. Remember, in these written agreements, you have to define what your fee is. So in this section, a retainer fee, the buyer is now able to determine that if there is a retainer fee that is allowed in addition to your fee, or will it be a part of your fee. And the next bullet point talks about that fee. The fee buyer shall pay broker at the time of closing the transaction is a fee equal to X% of the purchase price or Y dollars. The buyer may include in any offer to purchase a requirement that the seller pay such fee. Any amount that the seller and or listing agency agree to pay to the broker shall be credited against such fee. Should the broker or broker's agent procure a transaction and a seller fails to close through no fault of the buyer, or the transaction fails to close due to action or inaction of the seller, fees payable pursuant to this paragraph shall be waived. If buyer is at fault, the full fee shall be due and payable to broker immediately by buyer. And finally, legal notice. Failure to complete fee blank within paragraph 6 may be a violation of Alabama real estate license law and may cause the validity of this agreement to be called into question. So please fill in every line, check every box where it's asking you to fill in something appropriately. Finally, sit down and talk with the buyer about the services that you'll be providing. Since the licensing company are not agents of the customer, licensing company agreed to provide the following services for buyer as may be required and is allowed as a transaction broker. You would sit down and review all of those bullet points and other duties at the bottom that may apply to this client or transaction. 8 additional provisions can be added at this point and manually written in. Number 9 talks about signatures to the provisions of this agreement. And finally, the last page of the Valley MLS buyer showing agreement talks about buyer agency agreement. Again, so if there becomes a more formal relationship that's required other than just a transaction brokerage, where a single agent relationship or fiduciary relationship may be required, number 10 talks about that. Number 11 goes into fair housing, that the broker agrees and adheres to the standard of showing real properties made available to the buyer without regard to any of the protected classes named in paragraph 11. Number 12 is a disclaimer that basically says that the broker will provide professional services in the real estate realm, but they are not experts in law, tax code, financing, surveying, engineering, architecture, structural, environmental, other physical conditions, or non-physical details of the real property. So basically it's saying that if the buyer needs to seek professional services from inspectors, lenders, or attorneys, and so on, that they should rely on advice from those professionals. 13 talks about terminology, about when the contract and dates begin and end, as well as particular dates and holidays that would or not be included in calculating a time period under the period of agreement. And then finally, you'd have the licensee sign the document and date it, as well as the customer or customers sign and date the MLS buyer showing agreement. Moving on, we are going to now talk about the exclusive buyer agency agreement. This is to be used when a buyer or buyers want a real estate agent to assist the buyer in finding a home to purchase. This agreement creates a fiduciary or single agent relationship between the agent and the buyer. In general, this agreement contains what the buyers want the agent to do, what the agent agrees to do, and what the buyer agrees to do in return. Let's take a look at the exclusive buyer's agency agreement. Again, we'll start from the top and work our way down, whereas you would define who the purchaser or the buyer is, and you would grant to the brokerage company who is representing that particular buyer in this agency agreement. Paragraph 1 talks about the scope of services, where the buyer's agent services are outlined through A through E. This is an excellent time in a buyer consultation to go over each one of those particular items in detail so the buyer understands what services the agent is providing. Underneath that, it's just as important to outline the buyer's obligations and to review A, B, C, D, and E as well with the buyer so they understand fully what this agreement is binding them to. Below the scope of services, you're going to see a disclosure that says the buyer acknowledges that they are not currently under a buyer agency agreement with any other agent broker for the same term or same property as described below. This is where you would have the buyer initial that section. Very important that that's acknowledged. And then the last paragraph on page 1 talks about real property description and location. So you can talk about the types of homes that the buyer is looking for, and again, general location, whether that may be city, a county, a zip code, or subdivision. Moving on to page 2, talks about paragraph 2, period of agreement. And again, NAR will not dictate the length of this agreement, but it goes on to say this agreement shall be effected for a period of time beginning on a particular date and ending at midnight on a specified date. 3 talks about brokerage fees. 3A talks about the retainer fee. Again, that non-refundable retainer fee is to be paid by the buyer in the amount of X dollars at the time of signing this agreement. The buyer then would go on to acknowledge that they are aware of the retainer fee in Section 3A and that they are going to allow or not allow that to be paid in addition to the buyer's broker fee noted below in 3B. So 3B, we'll talk about your fee. The buyer shall pay broker at the time of closing the transaction of a fee equal to X% of the purchase price or Y dollars. The buyer may include in any offer to purchase a requirement that the seller pay such fee. Any amount that the seller and or listing agent agree to pay to the broker shall be credited against such fee. Should the broker or broker's agent procure a transaction and a seller fails to close through no fault of the buyer, or the transaction fails to close due to action or inaction of the seller, fees payable pursuant to this paragraph 3B shall be waived. If buyer is at fault, the full fee shall be due and payable to the broker immediately by the buyer. Please note that you can see in all caps here that these are some of the disclosures that are required from the settlement about talking about buyer-broker compensations are not set by law or governed by any realtor association or MLS service, and they are fully negotiable. The Association of Realtors and MLS services do not fix, control, recommend, or suggest fees or rates for the services of their members. Broker may not receive compensation from any source that exceeds the amount or rate provided in this agreement. 3C says if buyer or any person or entity affiliated with buyer enters into a contract to purchase a property falling under this agreement, whether the property has been introduced to the buyer by broker or not during the period of this agreement or within 30 days if left blank after the end of this term for property that is introduced to the buyer by broker, buyer unconditionally agrees to compensate or cause broker to be compensated at time of preceding sentence. The broker's commission shall be deemed to be fully earned by the broker, and the broker obligations hereunder shall be deemed to have been satisfactorily fulfilled, even though the buyer shall be awaiting the closing of a transaction, and the period of this agreement may or may not have then ended. In that event, the broker shall be under no duty or obligation to bring any other properties to the buyer's attention. Finally, 3D says the buyer acknowledges they are responsible for the agreed upon compensation to the broker. At the bottom of the page, you can talk about other provisions that may be discussed. Moving on to page 2 of the exclusive buyer agency agreement, there is another one of the disclosures that are required that have been added for you, where it talks about the brokerage fee is not set, but in all cases, can be set by negotiations between the broker and the buyer. Let's look at 3E, where it talks about purchasing a property not listed in the multiple listing service. This is basically giving permission to the agent or the broker that they can add a listing as a comp into the MLS if a property is not in the MLS, such as like a FSBO or for sale by owner. This is where the broker and buyer would initial 3E. Paragraph 4 talks about agency disclosure, the RECAD. Paragraph 5 talks about limited consensual dual agency and conflicts of interest. This would be a good conversation to have not only with the buyer, but maybe with your broker as well, if in a situation occurs where you may have a listing and you procure a buyer somewhere down the road, and that particular buyer wants to make an offer on your listing. This is where the discussion about dual agency and conflicts of interest would come into play. And again, a good conversation with the broker or reviewing the RECAD on how to move forward. Paragraph 6 talks about indemnification. Number 7 talks about the disclaimer. And then the last page of the exclusive buyer agency agreement talks about alternate dispute resolution agreement by binding arbitration. So that's important to know that we are going to arbitrate before we go to court. And then finally, non-discrimination talks about how properties will be shown and made available to the buyer without regard to any one of the protected classes noted in paragraph 9. Paragraph 10 talks about the entire agreement and shall be binding. And then below that, we're going to be talking, we're going to have requirements for the name of the broker agency, the buyer's signature, the agent's signature and date, and then again, making sure that each one of those blanks are filled in, talking about deposits or retainer fees, and again, making sure all the contact information is filled in its entirety. So if you have any questions about those particular forms, you can certainly reach out to Valley MLS support, or again, I would recommend you go to fax.realtor, look at the FAQs or the section on written buyer agreements.